Mr. Shima. I'll ask counsel in 125-006 State v. Stuart to come forward. As they do so, I'll explain a little bit about the court's presentation of the arguments culminates sort of a study that the court members have done of the cases. We have briefs received from the parties. We have records from the lower court proceedings, as well as research memoranda that we have available to us through our own staff. Through that, we have some fairly deep familiarity with about the case, the facts of the cases that we'll hear today. And this gives us an opportunity to probe deeper into the arguments of the parties and ask the attorneys some questions. With that, we'll ask Mr. Edinger to come to the podium so we can start with that. We'll try to let him get started before we ask the first question, though.
May it please the court, I'm Ryan Edinger, appearing on behalf of the defendant, appellant Tirrell Stuart. With the court's permission, I would like to reserve 3 minutes for rebuttal, please.
3 minutes is granted. Thank you.
Thank you, Your Honor. Tirrell Stuart brings this direct appeal before the court today, having been convicted of felony murder with the underlying predicate offense of distribution of marijuana. Tirrell, I guess I should say I would like to start by just focusing on the first issue raised in our appellate brief. Unless the court had additional questions regarding the second issue, I would submit that on the brief. Tirrell submits that this court must reverse this conviction because the state failed to prove the element of possession to establish the offense of distribution of marijuana. Furthermore, as a second prong of that argument, we are arguing that even if the evidence was sufficient to prove possession, the evidence remained insufficient to prove distribution because the state failed to put on any direct evidence of what Tirrell intended to do with that less than 25 grams of marijuana that he attempted to acquire on the date in question. I think I'd like to take a quick moment and just run through the facts of the case. At trial, Tirrell's friend Hannah testified that her friend Emilio contacted her through Facebook asking Hannah if she would like to buy some marijuana. Hannah agreed, arranged to meet with Emilio. Hannah, my client Tirrell, 2 other individuals then went to meet with Emilio to purchase the marijuana. When they arrived, my client on this particular instance was seated in the front seat. The other passenger, Hannah, was driving, 2 other passengers in the back. Emilio approaches the front of the car. The testimony is that my client Tirrell hands him $50. Emilio hands my client the marijuana. Hannah testifies at that point they go to pick up her sister Cheyenne from work. Once they picked up Cheyenne, they returned to my client Tirrell's residence, where she says that her friend Bones rolls a blunt and that they all smoke it. After this, sometime afterwards, it's made, apparently my client, is the testimony from Hannah and Cheyenne, my client wants to purchase more marijuana from Emilio, a larger amount, this time $200. So they, once again, Hannah contacts Emilio. They arrange to make another purchase. At this point, it's only Hannah, her 17-year-old sister Cheyenne, and my client Tirrell, who's seated in the back seat now. They go to meet with Emilio. Just as they're driving up to meet him, my client hands Cheyenne, who's seated in the front seat, the money. Is the testimony that both Cheyenne and Hannah said at trial. At that point, Emilio approaches the front passenger side window. He hands the marijuana to Cheyenne. Cheyenne hands him the $200. But at that point, Emilio says, "This money's fake," snatches the marijuana back from Cheyenne, turns to go back into the residence, and that's when Hannah and Cheyenne claim that my client then fired a single shot out the window, striking Emilio and taking his life. It's well established.
Was the marijuana in possession of Cheyenne?
And I think that's the critical question, Your Honor. And what we've argued is absolutely not. Possession, it's well settled.
Actually, you said an exchange occurred, and he snatched the marijuana back. So that does imply that it was physically possessed by Cheyenne. Is that right?
It sounds like from
and the exchange of whether it was true currency or fake currency also.
I think that matters, right?
I don't think it matters, but that occurred also.
That did.
Okay.
But I think what I want the court to focus on is what control means. So possession, it revolves around the idea of control. Well, what is control? Control is maintaining some influence or authority over something. There has to be some sort of temporal period there beyond what we're arguing beyond a here, no. As far as this transaction goes, obviously, Emilio wasn't pleased with the consideration here. This is fake. I'm out of this deal. This is wrong. So our argument there is that because there was no maintaining of any authority, that doesn't rise to the level of legal possession.
Let me ask you a question under 215701Q, which is the definition of possession. I don't see anything in there about maintaining.
Right, but it speaks of control. So what I'm saying is the definition of control is to maintain.
Where are you
authority.
getting that definition?
Control means-
There's a there's a citation in your brief that defines.
No, I haven't defined in the brief control. I'm just saying as part of my argument for the question is what is possession? Possession revolves around control. Control is a matter of maintaining some sort of authority.
And then
or-
you cite to Webster's for that?
Not in the brief, no. I'm sorry. I'm just making that argument this morning.
So your argument is that Emilio never let go, never relinquished control of the marijuana.
Not in a sufficient manner to establish legal possession. The testimony from from Hannah was that it was just in her hand. Cheyenne said it was momentarily in her lap. At that point, Emilio immediately grabs it back. And I think it's consistent with this court's opinion in the holdings and opinion in State v. Crosby, in Hilliard, and in Mora, where that marijuana never became fully under the control of the prospective buyer. And at the end of the day, when the person is shot and killed, where's the marijuana? It's still with the person who's there to distribute it, not with the person that was supposed to be buying it, which is the same exact situation that we have in this case.
Let me move you over to the distribution question. We got possession, but then we still have to have the intent to distribute or transmit it. Seems pretty obvious to me, reading the state's closing argument, that it thought distribution was the sale of the marijuana by Emilio to the car. And I think our case law doesn't support that. But I want to figure out whether the state maybe stumbled over the finish line despite itself. You have no problem with jury instruction number 6, which is the distribution.
Yes, right.
The
Jury
elements.
instruction number 6 says while he's in the commission of distributing
Okay.
marijuana.
So the fact that they had a party and they were smoking marijuana, and they go buy some more marijuana. He wants to go buy some more marijuana. Why isn't that enough for a reasonable inference that he was going to, and that's the argument that the state, that's kind of the fallback issue for the state, or the argument. Why can't you make a reasonable inference
I think
that
I
he was just buying it in order to share with his friends?
if I understand what you're saying, Your Honor, basically, and that's what the state's argument is that we can presume, we can make a
We can
reasonable
infer.
inference, right?
There's no question they were having a smoking
Well,
party.
I think if we really carefully parse the record, that there has to be some presumption there, because the state never asked a direct question, was Tirrell smoking marijuana with you? She said, and if we look at that first transaction, my client's not the one who instigates it. Emilio contacts Hannah. And the state's relying on that whole first transaction, that whole first situation, for an inference that my client was going to distribute marijuana.
Well, he's the one that paid for it.
Well, I don't know if the record fully supports that. He handed him the money, and I'll remind the court that when they got back there, Bones is the one who rolled the blunt, not my client. So apparently he wasn't in possession of it when they returned. Or at some point, Bones is the one with the marijuana when they get back, because he's the one that's rolling the blunt that they're smoking.
You
So
don't think that's circumstantial evidence of him possessing
think
and
it's- I think
distributing?
I think it's pretty thin. I mean, sure, he may have possessed it for that moment when he handed him the money and took it back, but it's very, I think it's based on a presumption, not necessarily a reasonable inference. There's a hole there, a big hole that the state never could have said, did Tirrell smoke marijuana with you? She said, we. Now, I've seen you see lots of, it's very important when I read transcripts, when people are being on the stand and they're being questioned, and they start saying things like we and they and us and them, counsel will frequently stop and say, look, we need to be specific of who
Why
we're
is
talking
it
about.
important whether or not he
Because it-
spoke with them?
Because that's engaging in distribution. He could have gone to his room and smoked some by himself. We don't know from the evidence here. That's my
But
argument.
but if he purchased it and then he goes to the house and distributes it and doesn't smoke any himself, isn't that still distribution?
No, I think you're misunderstanding what I'm saying.
I'm sorry.
I'm saying that the evidence is that if he, okay, let's say he purchased it.
Okay.
So we get back to the house.
Okay,
The testimony is that from Hannah directly. Bones is the one that rolls the marijuana.
okay.
Now, there's no testimony about where my client is at that point. Nothing. He could be in his room. Now, and that's my argument. There's no, that, when the marijuana is being smoked, it's, when they are sitting around smoking, that's where the distribution's occurring. There's no evidence directly that my client was there. It's all based on this presumption that by they and we, she meant to include my client.
I
The
thought
state never asked that
I
question.
thought the testimony was that he was smoking the first batch of marijuana because he liked it and
True.
wanted to buy a little bit
But
more.
I still have to argue that there's no testimony that means he was smoking it with anybody else other than himself. And when the state says that he goes to purchase that next, so when he goes to purchase that next, less than 20, there's no statutory presumption. We know it was less than 25 grams. So there's my argument, there's really nothing more than inference stacking here to get to the point that my client intended, or not even intended, but was distributing marijuana when he made that.
And that's where I want to focus you.
Okay.
Walk me through what's being stacked. In order
What's
to
being-
stack inferences, we got to have more than one.
Right.
That's
right.
why I was
So-
focused
Right,
on.
so I think there's at least three,
Okay.
basically three of them here. The first one is that, okay, because he purchased the marijuana from Emilio, according to everyone else's testimony, handed him the money, and took the marijuana. That means that the same marijuana that they got back to the apartment with was the marijuana that Bones rolled the marijuana joint from, was the marijuana that my client allegedly purchased. So there's an inference. We don't know. The state never asked. So the state never asked. So the marijuana that you purchased from Emilio, was that the same marijuana that you smoked when you got back together? There's a huge hole there. And then the second inference goes right back to that. Now they're back at the apartment. The next inference would be they, meaning to include my client, all smoked it together, the same marijuana. And then the third is because of that, he was going back to purchase it in order to distribute it again. So there's at least, that's where it starts to stack up. The state could have very easily clarified that. It could have asked. So that's the same marijuana that you guys smoked with what you bought? Yes or no? When you say we, does that include my client? Where was he? Did he go into his room? And just the fact that he liked it, well, he could equally cut the same way. He wanted to go buy more, keep it for himself. So I just think that the whole premise there is based on inference stack. Hope I laid that out in a way that you can appreciate what I'm saying. Beyond that, I think essentially that is the crux of my entire argument. First, in summation, we don't have sufficient maintenance of control to equal legal possession. That marijuana, just like in the court's precedents in Crosby, in Hilliard, and in Mora, that marijuana was was with the distributor at the time of their death, just like this case. And there's just no evidence beyond the state didn't put on any direct evidence to establish, distribution.
But
Unless
in
the
those
court-
three cases that you cited, would you agree that the purchaser never was in possession?
Right.
And it was like, either in a room or it was on
It was
the
on a dashboard.
dashboard, so
It was
nobody.
on a dashboard. The other person
Okay.
still had it like in their jacket pocket,
Mm.
that sort of thing. So, I mean, but I still, I think it's more consistent with those cases regarding, the question of possession than it is on anything else that I could find. So, with that, I see I'm out of time. Thank you, Jan.
May it please the court, the state appears by Assistant District Attorney Claire Cupido. Stuart did have joint control and possession of the marijuana during the second deal through Cheyenne, and Stuart did intend to distribute that second purchase of marijuana with his friends. The testimony from Hannah, if you look in the transcript on record 10, page 34, Hannah says, "We were all smoking." She had indicated who all was at the apartment, herself, Stuart, Juliana, Bones, that they were all smoking. Hannah indicated that in her testimony. That was after the first deal, the $50 deal. Then Stuart asked for more marijuana. He asked for $200 worth of marijuana and buy two. In the Facebook messages in between Hannah and Emilio, Hannah is saying along the lines of, "We ain't want to cop a lot at first till we knew it was cool. He just cashed his check and wanted more." Hannah was talking about Stuart wanting more marijuana. There is a reasonable inference that Stuart bought that $50 worth of marijuana, distributed it to his friends back at his apartment. There's a reasonable inference that his plan to purchase $200 worth of marijuana was to go back and share it with his friends.
What's the time frame?
I believe it's a few hours.
And is that in the record?
Yes.
Everything from first buy to the killing occurred in the space of a few hours?
Yes. Hannah and Cheyenne testify. By one is before they pick Cheyenne up from work. They go back and smoke. They pick Cheyenne up around 5 p.m. And then by two, I'm not sure if there's an exact time, but they said it was dark, but it is the same night.
And in terms of the second transaction, was there testimony in the record that the Emilio actually had turned away and then somehow observed something questionable about the currency? Or what is the specific testimony around that transaction, that second transaction?
Hannah was in the driver's seat, Cheyenne was in the front passenger seat, and Stuart was in the back passenger seat. The testimony was that Emilio tried to open the back passenger seat where Stuart was, and then Stuart was like leaned against the car, so he ended up, Cheyenne rolled down her window. The deal was done through the front passenger window. Stuart handed Cheyenne the money. Cheyenne handed the money to Emilio. Emilio handed the marijuana to Cheyenne for Stuart's behalf. It was his deal that he wanted. Cheyenne had possession and control of the marijuana. I believe the testimony, is that Emilio felt the money, said something along the lines of, this isn't right, then grabbed the marijuana, and as he was turning away was when he got shot. The possession part of it is that possession is having joint or exclusive control with knowledge and intent to have such control. Stuart requested the second deal. He requested it from Hannah to set it up. Hannah brought Cheyenne, her little sister, along. And because of where they sat in the car and where Emilio came to the car, Cheyenne was doing the deal on Stuart's behalf. He had handed her the money. He had requested basically all of the deal to happen through Cheyenne. He is the impetus for this entire deal. He wanted to have control, and the state's position is that he had joint control of the marijuana with Cheyenne. There is no temporal limit on how long Cheyenne and Stuart had to have that joint control of the marijuana.
Let's focus on the distribution aspect. You never introduced any evidence that there was an intention to share with any, right?
No, I think it's a reasonable inference.
And you didn't even argue to the jury that it was a reasonable inference that they were going to share, right?
Correct.
How is it even an inference? Because that's such a small amount of marijuana. It seems perfectly reasonable to infer that Tirrell smokes marijuana, likes it, and wants some more for his own personal use. That doesn't seem to be that outrageous of a leap.
I think.
Doesn't
oh,
the state have to have some kind of evidence that there was an intention on Tirrell's part to distribute the marijuana after he obtained it?
I think it can be an inference. The case law is clear that the intention, there has to be something, an inference or something. To me, the fact that there was a first buy and a second buy is what makes that inference reasonable, because they set up a $50 buy for less marijuana. There's evidence that they all smoked it together.
Is there evidence they all smoked that marijuana together? Or is this a BYOB party?
I think it was clear that it was that marijuana. I agree that that exact question was not asked, but they went to buy marijuana. They then smoked
What
marijuana.
makes it clear that they weren't all bringing their own product?
Because they all went together to the buy. They were all at the apartment. Hannah talks about how herself, Stuart, Juliana, and Bones were all at the apartment. They all left together.
They were all at the first buy.
And they all went, yes. Hannah, Bones, Juliana, and Stuart were all at the first buy, because there's the other testimony about them going to Gage Probosco's house on accident. So all of them were present at the first buy. The second buy, Cheyenne was not at the first buy. Cheyenne was then picked up from work after buy one. And then buy two was Hannah, Cheyenne, and Stuart. So they were all together at buy one. Juliana, Bones, Hannah, and Stuart.
Does that run afoul of the holding in State v. Mora? That when defendants jointly buy and share drugs, they're not distributing?
I think it's distinguishable from Mora. I also think because the second buy was only Hannah, Cheyenne, and Stuart, that the inference is that they were going back to the apartment where the other people were to share it. They weren't going to only share it within the three. I believe Cheyenne had no interest in the marijuana. She just went with Hannah because she was her sister.
So it's distribution if the friends don't come car, but if the friends were in the car, it wouldn't be distribution.
I respectfully disagree that sharing marijuana among friends is not distribution, but I think in this case it is specific that Stuart was buying it to go share with the friends both in the car and back at the apartment. The facts in Stuart are distinguishable from Mora, Crosby, and Hillard. In Mora, they set up a drug deal and then immediately pulled a gun and demanded the drugs and shot the dealer. There was no possession. The killing was immediate in Mora. In Crosby, the bag was on the center console or the dashboard. There was no money involved, and the defendant immediately said, "Give it up," and shot. That is distinguishable from the facts in this case where the deal was ongoing. It was happening. There was possession. There was money exchanged. Mora and Crosby were, when the killings were done, before a deal could even happen. They had set up a deal. That is clear what they were doing in Mora and Crosby, but it had not begun in Mora and Crosby.
But wasn't the underlying predicate, I mean, I might be wrong about this, trying to remember those cases. wasn't the underlying predicate felony an attempt in those cases?
I don't believe so.
And it was attempted distribution, right? Or am I wrong?
Oh, in, Mora, it was attempted distribution.
So whether the killing happened, I mean, that's why that argument doesn't necessarily distinguish those cases. Because the underlying question was, were they guilty of the felony upon which the felony murder was predicated? And I think at least in Mora, it was an attempted distribution. You have the same legal issue at hand.
In Mora, it was an attempted distribution. In Crosby, I believe it is,
But do you see my point about,
yes, and I still think the facts in this case are distinguishable from that, but, I do think Crosby was charged like this case was charged. And in Hillard, there was absolutely no evidence. In Hillard, this court ruled that she was conspiring to basically distribute to herself, like I have talked about with the inferences, with the one inference, that Stuart did intend to distribute that marijuana. He was never just purchasing to be a possessor or a user of marijuana. He was always engaged in that distribution to possess with the intent to distribute that marijuana.
Does the whole notion of joint possession or joint control, I don't know, on the one hand, it may, that's your argument to satisfy the possession element, but on the other hand, at least logically, doesn't it also suggest in terms of the distribution question that they're all also unified? Do you understand that
Yes,
question?
yes, I understand your question. I think it was more of where Cheyenne was sitting in the car. I think it's pretty clear from Cheyenne's testimony that she was not interested in the marijuana. She just went with her sister, that these were Hannah's friends, not Cheyenne's friends. She didn't want to hang out with these people. She just stayed with her sister. The deal was Stuart was handing her the money to be done on his behalf, but I do think they did have joint control, but she didn't really want to have joint control. Did that answer your question, or?
Well, I don't know. I think the notion that if you can sort of look at them as a collective unit in terms of satisfying possession, shouldn't it sort of logically be the same approach to the distribution question then, in terms of those actors being unified in their, in their conduct?
I think the difference between the joint possession between Cheyenne and Stuart is that if Stuart had completed the sale, had the marijuana, he would have taken it back to his apartment, shared it with Bones and Juliana and Hannah, and not necessarily shared it with Cheyenne. I think that is the difference. And thank you for asking that a second one.
And all of the arguments you're making today are not the arguments you made at trial.
Correct.
The state prosecuted this case as if the distribution occurred when Emilio walks up to the car with the bag of dough, with the bag of weed, and hands it to Cheyenne. And Tirrell hands the money to her. That's the distribution, because you say it doesn't make any difference if you're the buyer or the seller. I'm reading your closing argument. That's what you thought the distribution element was, and that's what you argued to the jury, right?
That is what was argued to the jury, yes.
So, now we're really just trying to backfill, provide evidence of a required element of this offense.
And I think the evidence was there, even if it wasn't directly argued in the closing argument. The evidence was there. The testimony was given about what could and was going to happen with the marijuana.
There's no evidence about what was going to happen to that marijuana, right?
The
That's
inference.
the thing. You never asked. Were y'all going to go back to the place and party some more? Or did you intend to be able to share some of that marijuana that Tirrell's getting? None of those questions were asked. And that's why I'm not even sure it's an inference, reasonable inference at least, to say that the intent was to go back and share that small amount of marijuana with anybody. That's just personal use. It seems to me to be just as reasonable that he was buying that for himself.
I think based on the amounts, the $50 deal and then the $200 deal, I also think based on what was said in the Facebook message about they didn't want to get a lot until they knew it was good. I think based on those facts that did come out at trial, that it is a reasonable inference that he was going to go share it back with his friends. Unless anyone has.
Couldn't you just as reasonably draw the opposite inference? In other words, if they shared the first buy when everyone was there, couldn't you infer that they weren't going to share the second buy since not everyone was there?
I think that's an inference that could be made, but I think at a sufficiency of the evidence, you have to look at all the evidence in the light most favorable to the state. Unless anyone has any questions on issue 2, I will stand on my brief on that. Thank you.
Thank you. You reserve 3 minutes.
Unless the court has specific questions for me, I would be willing to yield the time that I have.
What's your memory about this Facebook message? So
What I remember about the Facebook
Pull it out.
before
I go and pull it out, I just wondered
which aspect, because there were several.
Well,
It started
counsel
on-
just said the Facebook message to buy the second batch of marijuana.
something about, we didn't
We
want to get a lot.
we wanted a taste
Well,
before.
I mean, first of all, that's a Facebook message. The state never asked, is that what Tirrell told you? And that's just, so there's a problem with that's a Facebook message that Hannah said. That's Hannah's description. That's Hannah's. I don't know how you can even contribute that to necessarily to my client's statement when the state never tied it directly to my client. Hannah could have said, well, we just didn't want to get a lot at first until we knew it was good. I don't think there's any way to, the state could have said, oh, and about that Facebook message, is that what Tirrell told you? That, well, now he just wanted to make sure it was good, or did she just tell Emilio that to put him at ease about a larger amount? We just don't know. And I think that's really the crux of so much of what I'm saying about the inference stacking problem with the state's argument, is those questions were never asked to really flush out what a lot of these ambiguities are. The evidence is just not there because those questions weren't asked. I would surrender the remainder of my time.
You're asking for us to reverse the conviction. Would this be then a sufficiency where there's no remand and no new trial? What would occur?
Well, if there's insufficient evidence of the predicate felony, there's insufficient evidence of that the murder was, that's a missing element. So it's a reversal. It's a sufficiency reversal. That's the end of the story. Thank you.
Thank you.
Thank you. Thank you to both counsel for your arguments this morning. The court will take this matter under advisement.